The sixth principle is that it is necessary to determine the examinee's rights and limitations to access to the report and other personal health information. Now notice at this point in the process, we haven't done the evaluation. We're not there yet. At principle 6, we haven't started the evaluation. Or said another way, the evaluation begins when the phone rings. And the process is an ongoing one until you decide whether or not you're actually going to get into the room with this person and agree to do the evaluation. And that can change right up to the moment before you start asking, making your first medical inquiry. Determine the examinee's rights. You want to evaluate HIPAA and other state personal health information statutes. You want to take a look at the collective bargaining agreement for that particular agency. And because they will often spell it out. Portland Police Bureau, for example, has a collective bargaining agreement which says that the employee will receive a copy of the fitness for duty evaluation report. There's no question about it. They will absolutely receive a copy of the report. So know whether or not there's a collective bargaining agreement that stipulates it. Know what the agency policies and procedures are. Know whether or not what the law says about it. Now, my own perspective on this is that I think that there's good aggregate evidence across case law and statutes that would require an employer to provide the employee with a copy of the report. Not necessarily full access to your files. That depends on whether you're in Nevada or outside of Nevada. Nevada is the only state I know of where you're going to have full access. But outside of that, I don't think so, but certainly what you provide the employer. Now, most courts have found that any separation, that is a termination of the employee resulting from the fitness for duty evaluation, must be preceded by what is referred to as a post-deprivation Loudermill hearing. It's post-deprivation. Normally, Loudermill is a pre-deprivation hearing. Before you give a notice of intent to terminate, before you terminate them, you tell them what the evidence is that you have, what the charges are against them. You hear what their point of view is and their view of what actually happened. You let them tell their side of the story. Part of the Loudermill or Skelly rights, as they're referred to in California. Loudermill is the Supreme Court case, and Skelly is the state reflection of that. But in just two examples, Boucher versus Martin and Bass versus City of Albany, the court said, well, you really can't do that in the case of a fitness for duty evaluation. You can't have the Loudermill hearing beforehand because you don't really know what the charges are going to be. And the charges are viewed as the doctor's findings, your findings with respect to the fitness for duty evaluation. You find them unfit for duty for these reasons. And these courts have held, and others as well, that if you're going to be true to Loudermill, you can't just say you've been found unfit for duty. You've got to tell him why he's found unfit for duty. This is why I have difficulty with Marty Mayer's position that the only thing he wants from you is a one-sentence letter that says the person's fit for duty or unfit for duty. I don't know how that satisfies Loudermill. Now,
what does Marty say when you...
I haven't had this conversation with him because I doubt that there is a state and to my knowledge, there isn't a Ninth Circuit counterpart to this argument yet. So I don't think he's going to feel jurisdictionally obligated. These are outside of the Ninth Circuit, and I can appreciate that. But still, I mean, let's just be fair. If you were a police officer, you were compelled to submit to a fitness for duty evaluation, you're told you're unfit for duty, and you want to know why, and they go, sorry, we can't tell you. I'd be pissed.
Yeah.
I don't think you can block that. I think you're going to get there. I really think that it's just making things difficult, and why do it? Because they're even more pissed off by the time they finally get their records. Just give them a copy of the report. But you can't do it. So you have a copy of the fitness for duty evaluation disclosure and informed consent document that I use. It's in your materials. Feel free to use it. Again, just no attribution. And in there, I let them know. I'm not going to give you a copy of this report unless I'm told to do so by the employer or unless I have to do so under court order. But that's a matter between you and your employer to work out.